mention?
Any mentioning?
Any mention?
Item 5, my lord.
Item
Yeah.
5.
My file has been misplaced, my lord. Person directed to supply me the copy of the.
You can take it.
Your
Take
Lord,
it from
Mention.
soft copy, you can take it.
Yes.
What is, we have called for report. What is this matter is about? Is it against acquittal?
Conviction, my lord. Section 20B of NDPS Act, 10 years conviction.
10 years conviction. What is the status? Whether the appellant is still surviving?
Yeah, my lord.
As seen.
Call for the report, my lord.
You might be, maybe there 23 years in 2007. He will be
Yes,
there.
Yes, my lord.
Take the copy.
Copy also in the pen drive in the lower
Yes.
court records. my lord.
Yes. Yes.
Supplementary list item 1.
Report.
Item 1, appellant number 2 and 3 are dead. Appellant number 1 is alive.
2 and 3. There are 2 and 3. Appellant number 2, Biswanath Bagh and Kulu Manji. Expired. That's it. In absence of an application under 394. And insofar as appellant number 1 is there, he is there surviving. Huh?
Yes.
Appellant number 1 is surviving. Hence, the appeal, the present appeal survives through the appellant number 1 alone. Please the matter for hearing. Take it. Yes.
The friends report as till item 7 no report.
So far as that item number 2, we have received a report in September 2025 that nobody is residing in that locality and they could not ascertain the whereabouts. Still then we have issued another letter to,
He was 56 years in
Yes.
2005.
till then we have issued another letter to ascertain.
Okay. Order dated 7/7/2026 could not be complied by the state. Hence, Mr. Panagday seeks 1 more week time. Huh? 1 more week time.
Fine.
Leaves the matter next week. Yes, next.
No.
3
Till 7 report.
reports are there.
No, it's as in.
3, what is the
No,
status? No report.
I will receive it today.
You have received?
I will receive today, ma'am.
Okay, next week. Huh? Not compliant next week. 4 also, like that. 5, same. 6, same. 7, huh?
7.
Same.
True.
Yes, 7.
Item 8.
Last order, not compliant in 1 week time.
Inquiry permitted to withdraw on behalf of the OP party 2 minor.
8, okay.
File.
8. Opposite party number?
2.
How
He
can
he
you
has
withdraw?
prayed for recalling of the act.
You had moved an application.
Yes, OP 2
One
has moved the application.
Let us see. The matter was disposed of.
Disposed of matter on the consent of the parties, the proceeding was quashed. Subsequently, the OP 2 filed application to recall the quashing order.
Okay, it was disposed
Now,
of.
you want to withdraw.
Second consideration charges. While order dated 6/3/2024, the criminal miscellaneous case was disposed of on consent terms, huh?
Well,
On consent terms, on consent terms. Thereafter, the present application. What is this application? Is about for application IA number 3030 of 2024. No, 320 of 24. 320.
320 is the main case.
No, which IA is this then?
303, I think 303.
3030. Thereafter, IA number 3030 of 2024 was moved by the opposite party number 2,
In public.
seeking recall of the order dated 6/3/2024. Today, a memo has been filed by opposite party number 2 for withdrawing the memo is taken under records. Yeah, it stands withdraw. Yes.
Item 9.
may I please, Your Lordship? I'm appearing through virtual mode, Your Lordship. In the present
ma'am.
case, Your Lordship, I filed an application for modification of the order dated 8/10/2024, Your Lordship.
What is the modification you are
Your
seeking?
Lordship, in view of the said order, Your Lordship was pleased to direct the petitioner to go to visit USA, thereby furnishing a bank guarantee of 25 lakhs, Your Lordship.
Sorry?
Bank guarantee of 25 lakhs, Your Lordship.
Yes.
Subsequently, after coming from USA, he surrendered his passport and moved an application to release the said 25 lakhs, Your Lordship. However, the learned special judge Bhubaneswar rejected the said application, thereby stating there is no specific direction by the Honorable High Court to release the said security amount, Your Lordship.
Also, his trouble. And you came back, huh?
Yes, Your Lordship. Within the stipulated time, that is 3 months, Your Lordship.
Okay.
And also
Yes, what do you
surrendered
say?
the passport.
What do you say? There was a condition. Just see the order dated 8/10/2024. Order. Para 12. Read it.
Yes, Your Lordship. Alright, well.
Who is there?
Mr. Maharana was there. His husband.
This is the order. Just see, you can also assist. Para 12, it says that because of flight risk, 25 lakhs was
security
asked to be
Yes.
filed security
Yes,
to travel to USA.
in lieu of his travel.
Yes. He traveled and came back. He wants back his money.
Yes, Your Lordship.
It has to be released. As and when he will go again, he will ask for. I'll just pass it over. Let the vigilance
sir.
council come. Huh?
Yes, Your Lordship.
Okay. Yes.
Item 10. That's item number 10. I'm seeking a short adjournment. I'm being led by Mr. Milan Karungo. He's had a vertigo attack today.
Why this matter is there?
That's what has happened at alerts may see order dated 21/5/2026.
Yes. In the event the learned SDGM Paralakshmi Gajpati reject the bail application of the petitioner, it is open for the petitioner to approach the higher court.
Malad,
And if such application is moved by the petitioner, the same shall be considered by the court below on the same day.
Malads.
And what do you want then?
Malads may come to order number 2, which was dated 13/1/2026.
Yes. Yes.
The last paragraph of that order,
Huh?
sixth paragraph,
Yes.
last page.
Take into consideration both
My lord
parties.
said, granted, no coercive action shall be taken against the petitioner for 6 weeks. The important purport of this order, my lords, was that I was to apply for bail in the lower court, and supposingly my bail was rejected by the
Yes.
lower court,
Yes.
the coercive protection would remain, and I was given the liberty to move the district
No,
court.
that's not the idea. 6 weeks time was granted. Within that 6 weeks, you explore all the possibility.
Yes, my
Not
lords.
that you enjoy this order and you move regular level. What is this?
No, my lords, that is not. I mean, I bow down before my lords. My lords, the issue is not that. What happened is after the 6 weeks order was given,
Huh?
the accused
See, the
sisters,
6 weeks, see, that is 13th January 2026.
my lords,
6 weeks is over. Within 6 weeks, you could have explored all possibility, whatever possibility.
my
you have.
lords.
Not that the 6 weeks will keep on extending.
No, my
And you
lords,
get
that is
till
not.
Supreme Court you go.
No,
get
my lords,
rejected.
that is not my intention, my lords. What had actually happened is that the accused sister's marriage fell within those 6 weeks. The difficult.
Those things you move separate application.
No,
I
my lords,
can't.
my lords, I came before you. I placed these facts, and my lords was pleased to modify this 13-1 order
Yes.
by the
Order dated 21/5.
21/5.
Uh,
My only difficulty is that, my lords, I genuinely want to participate in the trial. There is a previous order wherein in another CRLMC, my lords has given me the liberty to move for discharge before the district judge. The matter is currently pending before the SDJM. Now, until unless the file is committed to the court of the district judge, I will not be able to
See,
file
I'll tell you, you can't be treated special.
No, but that is
You
not-
have to follow the procedure. Some protection was given, not that in the guise of that protection, you have to keep on
Well, that
asking,
is not- that is
moving
not- that-
application after application.
That is not my intention, Malad.
You may not say that you are not intention, you don't have the intention, but is that reflecting from your application? What are you asking in the application? Let us see the application. Let us see.
Malad, only
What modification? 21 order? What 21 order? What modification you want?
that my prayer is, under the facts and circumstances, the petitioner prays before this honorable court to be pleased to allow the petition further be pleased to modify the order dated Amuka by granting protection against coercive action by the court in session of the matter and extend the date of surrender.
See, that was, sir, extended subsequent order.
Malad,
See, your
subsequent order,
sister's
no.
marriage was in February.
Malad.
Today we are in July.
Malad.
You are asking extension. What is this?
No, Malad, my mind just before vacation the matter came up. And Malad was pleased to modify the thing. Only the thing is that coercive action, since that line was missing, we immediately filed for modification, Malad, and it came here.
No,
It's
you
not that-
please. Somehow I wanted to give some relief for
my
that.
bad luck. My bad luck, Malad.
Loosely, I use a small word in an order. It doesn't mean that you keep on moving application and after
No,
application.
Malad, that is not my intention.
I
Malad,
don't-
I was never before. I mean, I've never done this before the court, Malad, and I've
No.
never been, Malad, as an officer of the court, I'm conscious of my duties towards Malad also. But
So
Malad,
then you tell
Malad,
me.
it's a genuine.
See, you tell me. You are seeking modification of order dated 21/5/2026.
Malad,
What modification? You want?
Malad, only if Malad may grant me that coercive protection, Malad.
That is anticipatory base. Just see which part I'll read. You tell me. Read 5, para 5. Para 5 read.
For reasons stated in the application, he must allow the petitioner around 4 weeks' time from today to surrender before the court below. NBW issued against by the Residuum Parliamentary Gajapati in ICC shall not be executed. Petitioner surrenders within 4 weeks. In the event the learned Residuum Parliament rejects the bail, the petitioner it is open for the petitioner to approach the higher forum.
This is what you asked
No,
on
but-
modification. I have did it. Now you want that I should add that no coercive action.
No,
That means no coercive action will remain intact. You keep on trying there in the Sessions Court, High Court and Supreme Court.
No,
well,
no,
you will not.
no,
What
Malad,
is this?
no, Malad, that
Don't
is
be
not
unreasonable.
Malad,
Don't
this
be
is not
unreasonable.
the Malad. May I read the order dated 13/1 for a moment, Malad?
Yes.
Malad's paragraph.
In a criminal miscellaneous case, CRLMC, I give this much indulgence. Doesn't mean that you are. This is the order should have been passed in a anticipatory bail application. Your bail application is
my
rejected.
difficult-
I gave indulgence.
My difficulty.
I gave indulgence. Doesn't mean that you keep on moving.
I'm-
Don't
this
text.
is- Malad,
Don't.
my-
I think you should stop
Malad,
here.
Malad's.
Have you surrendered or not?
I have not.
You surrender.
Malad's.
Surrender, move application.
One line.
Same day your application will be
Malad's
dismissed.
one line, Malad,
Yes.
one line, Malad's. Malad's paragraph 6, taking into consideration submission by the parties, I'm of the view that the order dated Amuka passed by the learned SDGM Parliament in Vice, whereby NBW was issued against the petitioner shall not be given effective for 6 weeks. Now, next paragraph, Malad, in the same paragraph, Malads have written no coercive action shall be taken for the petitioner for the 6 weeks. It is possible, it is expected the petitioner
Yes.
shall explore. But my difficulty is, Malads, these.
That 6-week order I gave in January.
My lords,
You didn't do that.
My lords.
Moved an application.
my lords.
Got it modified. And now another application for modification. What is this?
My lords,
There should be some
no-
limit.
no-
Indulgence doesn't mean that abuse. Please don't do that.
My lords,
Right,
may-
for the reasons stated in the
My lords,
application.
my lords,
The application.
My lords may hear me for 1 second. My lords may just pass it over because the senior was supposed to assist me. He's not there, my lords. Maybe he'll be able to assist
See, I'm
me better.
leaving you here without imposing cost. If you senior comes, I'll impose cost. Take it
My
or
lords may take-
take it or leave it.
Let's
Take
pass
it or
over.
leave
My
it.
lords, please.
See, in this process, what is happening, you try to understand. Then I will stop giving indulgence. Where
Lords,
strictly I will go by law, then you are out. I am just giving indulgence because you should not be arrested. 6 weeks I gave in January. Thereafter again extended. Again, I said that, okay, you surrender another 4 weeks.
1
in
week time,
May,
2 weeks
and I
time.
said that on the same day your bail application should be disposed of. The Superior Court also disposed of on the same day. That indulgence again in a modification application I gave indulgence. And you are moving another application. Is it not an abuse of process of law? A court which is indulgence doesn't mean that you keep on taking orders after orders.
I've been really grateful for you for the indulgence.
I will leave you here without imposing cost. Dismiss. I'll write a detailed order, then you will be in trouble. Just no indulgence. Yes. Simply. The modification application stands dismissed as the saying is devoid of merits. Yes.
Item 11. Please, my lord. But I have sought for cancellation of the bail in respect of opposite party number 2.
Why?
My lord, may kindly see page 16, my lord.
The
The conditions imposed by my lord while granting the bail.
what are the conditions?
He was petition number 1 in that bail application, my lord.
Yeah.
So far as petition number 2 in that bail application is concerned, your lordship rejected his bail application. So far as this person is concerned, he was petition number 1 in that bail application.
Hmm.
He was allowed, but with these conditions. He shall appear before the IAC on every Sunday also. Second, he shall appear before the trial court on each date. Third is, he shall not leave the jurisdiction of the trial court. He shall not tamper.
Which one is now violated?
My lord, he is now, after getting released on bail granted by my lord, he has started threatening the
Have you registered any case thereafter?
Yes, my lord. I have
Okay. Issue notice.
included a
I'll issue notice. I'll issue notice. To opposite party number 2 to be served through the IOFO, the concerned police. Which police station? IOFO, which case?
Bansada.
PS case number
PS case
135 by 2025.
PS case number
135 0135.
0135.
I have given that as NSF 2, my lord.
And which police station is that?
Bansada.
Bansura.
Bansada.
Bansada.
Bansura PS case number so and so. Number there. ठीक. Serve. Okay. Yes.
Item 12.
After 2 weeks. Item?
12.
Yes.
The point which I am canvassing before the person is
Hmm.
whether without making the company as a party,
Hmm.
can the complaint case be maintainable? My lord had posed me a question last one, that once he gives you a notice under 138, and here he mentions such and such, managing director such and such, will it suffice the notice or not? My answer would be subject to correction by your lordship. No, because it is given to a person, not to the company.
Where is that notice? Can I
Yes,
just see?
notice they had produced last occasion.
Just see. Can you give me the notice? Notice.
Rather, in my
At page 17 of the at page 17 of the brief notes.
17?
Yeah, of their brief notices in post
Okay.
notes.
Yes, notice.
Page 17.
Yes. This notice is Dilip Kumar Patel, Managing Director, ISAR so.
Yes.
If you say that ISAR Engineering Private Limited through Dilip Kumar, it would have been different. Huh?
Because it's a lordship 138 is technical.
What is falling for my lords is
Take a wrong Usati. Wait.
Yes, it.
My lord, it has been given to whom? It has been given to Dilip Kumar Patel, managing
I
director.
understand. It is by name. It is given.
Then your lordship may see the averments in the complaint.
Complaint case. Yes. Yes.
My lord may kindly turn to page 8. The
And who all are the accused? Let us see. Accused is
accused is only Dilip Kumar Patel.
occupation contractor.
Yes. Managing director, ISAR engineer. Now your lordship may see the averments. page 8.
Yes.
The complainant is the proprietor of Messrs. Rudra functioning at such and such.
I read next paragraph. The
Yes.
accused happens to
They
be
happens to be the
organized.
contractor
In 2000, the accused being the organized
A
contractor.
recognized contractor had taken various material at such and such.
He has been taken as an accused as a contractor, madam. Well, three checks have been issued by the accused. In one case,
Let us see the checks.
in one case, Lord SDGM has same point, same thing, because there also the accused has received the materials as a contractor, not as the managing director of the ISAN. And my lord, that has been elaborately dealt by the Lord
No,
SDGM.
what check amount is?
Check amount, my lord, two cases have my learned friend has filed. One is 1,50,000, other is 10 lakhs something. 10 lakhs. And the other check where conviction has already been made in that case, the 10,50,000. They are also same argument was
But just see, if you see page 19, just see 19.
19.
19. The check.
Madam.
If
Check is of the company, but he has
No, authorized signatory.
for
Authorized signatory. Who is signatory? Who is authorized? You say in the complaint he is a contractor.
contractor. But he has received the material as a contractor, not for the company. That is the notice, that is the averment in the complaint petition also. That you as contractor has received the materials worth this much and you have issued a check. And that was also raised in the case.
Now, whose signature is this? Authorized signatory.
After signature man the accused, Dilip Patel.
But this is a limited company.
What has actually,
Anita Hada.
let me see. I should not give a copy of the order judgment passed by SDGM. This point was raised and all the judgments, including.
What happened to that judgment? Have you challenged that judgment? It's pending.
Because here is the case after this conviction.
Sessions Court.
After this conviction was made in the year 2024, they suddenly rose out of slumber, so to say, because cognizance was taken in the year 2018. They came challenging the cognizance in the year 2024.
What is the stage now?
There, my lord, I have instructed them, my lord.
What is the stage, Mr.?
Your Lordship has stayed it.
Stayed in the year 2024.
No evidence has been started.
No, stayed in the year 2000.
But how will you get over this? This is bound to be a case of acquittal.
My lord,
This
may be seen in judgment. Paragraph 17, sorry, page 17.
17, okay.
Yes, but it is pertinent to mention here, from a bare reading of the complaint petition, evidence of the complainant, it can be found the petitioner has filed this case against the accused in his individual capacity. The complainant has not advanced any allegation regarding commission of any offense or business dealing made by the company. He has clearly indicated the liability of the accused towards him in his individual capacity. Further, not even a single scrap of paper has been brought in evidence by the accused. The accused, although disputed his signature on the alleged check, but has failed to prove such dispute. Hence, the accused cannot free from his liability that he is liable to pay the complainant.
No, then you just this is a
and my lord, judgment.
You have to satisfy whether if a check is issued by the company.
About proposition
can you
of
prosecute an individual?
My lord, I am quite conscious about the proposition of law. I have got the judgment of Karnataka High Court. I am searching further, my lord. This point was raised. An answer given by the
Then now the recent judgment. Just now, Justice Manmohan's judgment is very, very clear on this point.
Right.
Which part you are showing? Here also
My
Anita
lord,
Hada and
my lord,
Himanshu judgment
from page 35, paragraph 16 to.
35. Huh? Okay. Yes. Yes.
Valid.
Para 16. A short point.
Valid. The short point that arises for consideration the manner in which the accused has been described in the cause title of the private complaint. On perusal of the called out portion, it becomes evident that instead of describing the accused in the conventional form as is hierarchies of company represented by CEO or MD, the complainant has inverted the description first mentioning the name of the director and thereafter appending the designation and the company's name. Such a board of description, though somewhat irregular, does not alter the substance of the pleading.
No, this would have been, I understand this.
My lord.
See, therefore I asked,
My lord, may kindly
but
see-
in the complaint, what have you written?
My lord, may kindly see paragraph 17.
Huh?
The cause title, when read as a whole, clearly establishes that the company is very much implicated as an accused. The only
I know,
the only,
I am with
the
you.
only discernible defect
Huh.
is that the director who signed the check has not been separately arrayed as accused number 2 alongside the company. Such an omission is not a nature that renders the proceedings void ab initio. Rather, it is a curable defect that can be appropriately remedied during the course of proceedings.
No, see, I'll tell you, the distinction is, this judgment will not be helpful to you because if in the complaint, if you have said, you have made any allegation against the company and the company is not made the party, then it is a curable defect. What you have done is,
I have made
you company has issued the check on
not
behalf
company,
of the,
but I have not avoided a single line.
therefore the judgment is not coming in your
I have not avoided a single line in the body of the company.
company is, you have kept the company out. You have kept the company completely out.
Out of.
You say it is an individual dealing.
Right.
Individual dealing.
Right.
But if you see the check, it is issued by the company. Authorized signatory.
No.
He doesn't.
That check, my lord, that check has been, the company's check has been used by the accused.
Where have you written that in the complaint? Where is the government? That's the whole difficulty.
My lord,
Otherwise, you would have direct. See, situation would be.
For that reason, my lord, I have asked for the statements recorded by the complainant during inquiry and the further proceedings. My lord. I have, day first day, I have tried because I had.
See, you would have directly covered by this judgment. If you would have, you would not have.
That I have sought for.
Company, you have not made party, no problem. Then if you would have said, in the absence of company, you can't prosecute.
No,
and then you would have covered. But today, what had happened is, you say that company has nothing to do with this case. It is only the individual. Company has issued the check.
I do not know, my lord, because it's a case of 18 and my lord friend has come in the year 2024. 6 years have been passed in the meantime. And in between, one case of same year, because it's a once is in
I'm worried about one thing. If I write something, he will succeed in the appeal also.
They may. I don't know, madam, because it depends upon if a lawyer.
That's the whole difficulty. This I don't agree with that SDGM order.
My lawyer friend says he has annexed the.
Yes, page 11.
11. Let us see.
Yes. And the complainant, I have filed.
That is the initial statement.
Yes.
Statements, whether the case has been started.
Your Lordship, see paragraph 3. The accused happens to be a recognized contractor in the year 2017.
That's the whole difficulty.
Being a recognized
That's the whole difficulty. If you would have said something about the company,
yes,
even if you have not included the company,
High Court judgment squarely.
Yes, let him complete.
Paragraph 1.
Okay.
And the complainant, I have filed the present case under 138 NI Act against the accused Dilip Kumar Patel, who is a contractor and managing director. Isar Engineering Private Limited, the district of Sundargarh.
Thereafter,
Valid. So,
wherever you say that on behalf of the company, this has been done.
now on behalf of company, I have never said because he has received the materials.
Unless you link your case with the company, perhaps you can't survive the complaint. You have not made any link with the company, whereas the company is apparently issued check.
My lord, I do not know, my lord, because that was not his stand also in the earlier case. That was not his stand while
That's what I am worried. If I write something, that earlier case will also go.
my lord, that he has not taken that stand also in the earlier case. Here also in this case, I do not know, my lord, the proceeding to how far it has come, my lord, because it's a case of 2018 and my lordship has come in the year 2024, challenging the order taking cognizance. I do not know, my lord, because this initial statement was recorded in the year
18.
16 for 18. So cognizance has been taken after that, and 6 years, my lord, in between has been passed. After receiving the brief, my lord, friends will have sent for the records, but
I'll put it next week then.
my
My
lord,
lord, I have cognizance order, I have given page 14.
cognizance order तो ଦେଇଛନ୍ତି ଆପଣ 8/8/18 ର cognizance order.
No, what he says that in between any evidence has come out.
Huh.
Even if evidence comes, nothing will.
It's come, my lord,
ଦେଖିବା
point of law.
my lord,
Now-
My lord, it is a point
my
of
lord,
law.
keep it next week.
How many adjournments they have taken, my lord? It's a point of law. And the Lalit Bediwala judgment covers squarely this point.
You are-
Karnataka judgment is to be simply ignored. Karnataka judgment
ठीक
is not
है, ठीक है।
taken into
No,
consideration.
Karnataka judgment would have helped him if they linked the complaint case
Madam,
with the company. You have not linked you have kept the company completely out in the complaint, though the company has issued. So you have in every side you are in difficulty.
I know my position in this case. So don't.
Therefore, you are enjoying stay 1 week.
Sir, one point. So question is, my lord, my learned senior is relying.
Last date of hearing when you argued, I said,
Yes.
I have reserved a judgment
Yeah.
on this point.
Madam.
I have already came across this judgment also. I'm trying to distinguish, but in your case, facts of your case is telltale. It is very difficult.
Saying your lordship may reserve it. We don't know after Friday what will be the bench position. My lord, I should.
And it will be same condition.
No, but what is this, my lord? Your lordship may say how many adjournments they have taken. Every day and there, every day adjournment was sought for. How many
I'm not
adjournments have
accustomed to this type of shouting.
No, you have stay also.
My lord, I have a stay, but question is, my lord, every day I have to come and disturb your lordship.
Yes, I can reserve the judgment if you
But let me
can.
do whatever, like he's shouting, but I am not allergic of this type of.
I'll pass it over then.
But-
He will cool down after lunch.
No, it will not pull down.
My lord, this sort of behavior is not expected from my senior. It's my natural voice, my lord. I cannot keep my voice at home and come here.
And let me close it and pass.
Written note of submission.
Yes, madam.
You give the judgments explaining whatever you want. Yes, he should be the. Yes. Next.
Malads, I may be pardoned, Malads. Item number 10, Malads was pleased to dismiss it. Malads, may just extend the order by 2 weeks. Malads, I'll surrender before. This is the same order, Malads. Malads, I'll completely fall down. Malads,
Okay.
just
No, please, I expect no further application. Huh?
no further
No.
applications.
Right now. After arguing for some time, then counsel for the petitioner seeks to withdraw the application for seeking modification and submits that 2 more week extension of 2 more weeks for surrendering may be granted in view of the statement made by the petitioner.
Malads, I may
2
be.
weeks time.
Malads, if my order is rejected, I may move. I may be given the same liberty of moving the court.
Same 2 weeks I am granted. 2 weeks time, no? 2 weeks for the time is granted for the petitioner to surrender before the court below. But paragraph last order, in same day to try to surrender, it will application will remove and if in the event it is rejected, it will be decided by the Superior Court on the same day. Okay. That's a fair way of doing it. Yes.
Item 13,
Yes. Yes, 13. Where is he now?
similar to 12.
Oh, two matters.
12, 13, similar.
Oh, same matters.
Same matter.
You give an exhaustive written note of submission. Okay. Yes.
Item 14, 14 map is
The instruction received in this matter, if Gopal Krishna Sahu has forwarding Milmilots passed away, but we send someone to the house also, the house is locked and no one is available. Need some more time to find out.
The complainant has died.
Yes,
You are for complainant.
I am for a petitioner.
You are appearing for a complainant, huh?
Yes.
You have to get the information because it is your revision.
Last. I don't know who solve us address proof of that Gopal Krishna Rao.
Because it is your petition. In any case, you have to, implement the LRs if at all they are there. Because you have been convicted by the courts below, you have filed the revision, isn't it? So therefore, you have to bring the LRs up for the complainant.
Last order by Lord Palace.
He will only help you, that's all.
They have to address proof.
You ask your client, what is the check amount?
1,40,000.
So just ask your client.
He said him notice.
So then it will go on and on. Then there is no end to it. You have been convicted by two courts. Okay. I'll dispose it up. If the complainant is not there, if for 1,50,000 rupees, the 2014 this revision is pending. You have been convicted when, you tell me? 2011 appeal. And the complaint case is 2009.
Yes.
How many years the High Court will take the pardon?
That's order number 7, 21st of May 2026. We have informed the court that the complainant has passed away. We have to substitute the LR.
Then
Substitute your lordship kindly see thereafter order last order lordship kindly see
made clear that the land counsel for the opposite party
7/26.
complainant failed to supply the details available of the GST party to the counsel appearing for
Also directed us to supply
the
details
the
of
matter shall be
the-
proceeded with the yes. Now he's not giving whatever the consequences are. It is your revision, you have to survive the revision. Ask your client, you can't jolly well sit in the house and all the entire court and all the lawyers will be prosecuting his case. It is his case, he has to prosecute. He has been convicted by two courts. Right. By the order dated 21 on 21/5/2026 and the matter was the revision petition was heard. The learned counsel appearing for the opposite party oblique complainant informed this court that the complainant oblique opposite party has already expired. This on 7/7/2026, this court directed the counsel appearing for the complainant of the opposite party to supply the details of the LRs of the said complaint. Neither the petitioner nor the complainant could supply has made any endeavor to bring LRs of the complainant of the complainant of opposite party. This case is arising out of a complaint case filed in the year 2009 for on the allegation of dishonor of check of rupees 1,41,537 rupees. The petitioner was convicted by the court of SDJM by the judgment dated 15/7/2021. 2011 in 1cc case number 358 of 2019. The appeal filed by the petitioner was also turned down by the Sessions Judge Niagara by judgment dated 31/1/2013 in criminal appeal number 20 of 2011. The present criminal revision petition is pending since 14/10/2014. In view of the long pendency of the revision petition and no efforts being made by the parties to bring LRs for the deceased complainant and complainant of the opposite party, no further adjournment. Liable to be entity, liable to be entity. Next paragraph, be that as it may, by way of last opportunity, the petitioner is granted 2 weeks' time to move appropriate application for bringing LRs for the deceased complainant of opposite party, number 1. In the event the petitioners fail to move for such application within time, the revision petition stands dismissed without reference to the court. Yes. 2 weeks time I have given. You will do it, otherwise it will be automatically stands disposed of. Yes, next.
Date fixed, madam.
Up 2 weeks, 2 weeks.
2 weeks.
2 weeks. I will look at the 2 weeks. 2 weeks when I just see 2 weeks means
28, 30.
30th. ठीक. Yes.
Item 15.
What was the check amount?
11 lakhs 50,000.
Ah.
Out of 11 lakhs, paying the 2 lakh draft today. Arrest amount will be given on instrument active for a file.
We have filed the affidavit that the rest of the 9,50,000 they are willing.
Where is the affidavit?
I just got the affidavit.
Give me the.
I only paid, give me which time I will verify that. They have showed their bona fide by paying the 2 lakhs rupees and 9,50,000 they are willing to pay within 8 months. And the last occasion, even though both the parties were here, they had orally submitted, they will pay within 6 months. So my client had heard that 6 months. So now it is 8 months. Only I will inform.
All right.
I'll only inform.
I saw that. Where is the signed one? I'll pass it over. Bring it, I'll dispose it up and giving you liberty to revive if they don't comply.
I'm pending on your nursing may pass that out.
No. I'll dispose it up today. I'll tell you, you will be in a advantage position in the sense, whatever money he has given, he will lose that and you will revive it. That's better. No, obviously. Whatever he is giving, the money, 2 lakhs and whatever he is giving, in the meantime, if he will not comply
If will not stick to the time.
and it will stand revived.
Right.
And the money will be forfeited.
Right.
You will be benefited.
Right.
So better that you do it. Huh? Pass over. Huh? Get it. I'll do. Yes.
Item 16.
Item 16 wheeler. We take some instruction. I pay some more time to file the affidavit.
What affidavit?
That is the comply of the order of my notes.
I have a class page 9 para 5.
Contempt.
Content. The order date is 7/11/2014.
7/8.
7/11/2014. Page 9 para 5.
Yes.
Be that as it may, I feel it appropriate to dispose of the petition with the direct of the party to do well to see that the petitioner's final pension and other retirement benefit which is sanctioned and dispersed expectation. If there is no other legal impediments, the petitioner shall furnish all necessary documents to the opposing party to satisfy regarding the entitled pension or other retirement benefit within a period of 2 years, and the opposing party shall do well to see that the final decision on the same is taken easily 4 weeks thereafter.
Have you supplied the copies?
Answer 2 series man.
We are receiving all these things and the instruction also received. I tell next week you can file the application.
Okay. Last opportunity next week. Huh? Last opportunity. To file complaint next week. To file the complaint affidavit. Yes. See, under the pressure, they will do it. If I'll dispose it up, you won't get anything. Let it be pending. You are interested in your pension. Let it be pending so that under the pressure, they go in. If I'll dispose it up, then you will keep on running. Nothing will happen.
Suffering from brain stroke.
Wait. 1 week I am giving so that under that pressure, they will do it.
Man.
Please see that it is done because he's suffered a brain stroke and all. At least if he is entitled to pension, give it. Yes.
Hearing matters.
Yes.
So every item 32 may be taken up.
Serially, let us see. Mr. Dhanal, you are waiting for which matter?
22.
22, 23. Anyone prior to that, prior to 21, 23? You, Mr. Mishra? You are for
18, I was asked to assist your lordship, my lord.
18, huh?
Yes.
Yes.
And senior counsel, Mr. Milan Kanungo is there for the respondent.
Okay.
He is not there.
So I have requested you to assist.
Yes, yes.
Yes.
Pardon?
So he is not there.
He
It's
is not there. The respondent advocate is not.
he has some personal difficulty or what? Mr. Kanungo has some problem.
Yes, he was saying that.
That's what he was saying.
Your lordship may call it any other day.
Malaks, on behalf of Mr. Kanungo, I am here, Malaks.
Yes, yes.
In this case, we have obtained all the case records, Malaks, and Mr. Kanungo is suffering from vertigo, actually, Malaks. For that said fact, Malaks, a short adjournment.
Okay. Let it retain next week. Okay.
1 week after, Malaks, may I please?
Yes, yes.
Because
Next
we have
week,
current
next-
contact.
Next
Great.
week. Okay.
Great.
Thank you. Yes.
22.
Then you start. Let him come here. 32.
32. Yes, sir. I may be permitted to submit on behalf of Mr. Videsh Behra. The appellant, my lord, has challenged the order of conviction passed by the learned additional sessions judge Bhavani Patna, wherein he has, while the learned trial court, while acquitting the appellant of the charge under section 376, has convicted him under section 417 IPC and sentenced him to undergo 1 year of rigorous imprisonment and fine money.
Yes.
The prosecution case is that the prosecutrix lodged an FIR dated 9th of April 2008, alleging therein that she was in a love relationship, mutual love relationship with the appellant, while the appellant used to come to her village to appear for his matriculation exams. In the course of time, they developed physical intimacy. The appellant allegedly had promised that he would marry her. However, it is pertinent to mention that the appellant and victims were almost similarly aged, my lords, that is around 19-20 years.
Yes.
However, however, in the meantime, the victims, the prosecutrix marriage was fixed with a third person, my lord. The appellant allegedly called up that such person and threatened that he is in a physical relationship with the prosecutrix, and he threatened him not to proceed with the marriage. Thereafter, allegedly, the marriage was called off. A village meeting was convened wherein the appellant's father allegedly gave his word that if it was found that the appellant had kept in a physical relationship with the prosecutrix.
Read 415.
Yes, ma'am.
450.
415 defines what constitutes cheating.
Yes. Whoever by deceiving any person, fraudulently or dishonestly, induces a person to deceive to deliver a property. First of all, deliver a property to any person or to consent that any person shall retain the property, or intentionally induces a person to deceive to do so or omit to do anything which he would not do or omit, and if he were not so deceived, and which act or omission causes or likely to cause damages or harm to that person in body, mind, reputation, or property. Yes.
So, my lordship, as my lordship sees, section 415 of the IPC envisages cheating with regard to delivery of property and deceitfully inducing or deceitfully inducing the victim or the prosecutrix and misleading him or her to do or to omit to do something. So the second part would be relevant for the present case, my lord.
Yes.
So, my lordship, with regard to allegations of false promise of marriage
my lordships have consistently held that what would constitute deceitful act has also to be seen in the context of section 90 of the IPC, which defines like what would constitute misrepresentation, which vitiates consent which has been obtained by misrepresentation.
Yes.
My lordship, before going into the elements of the section, may I first place on record before my lord the relevant portion of the judgment wherein his findings has been given as to how the case will not come under section 376, that is rape, but would constitute only a case under 417 for
Which para?
internal page 8, paragraph
9. Para 9. Here read it. Now I
Now
have.
I have to find out if from the facts proved above, the accused can be held guilty for the offense of rape punishable under section 376 IPC. In her evidence during cross-examination, the victim girl admitted that her date of birth is 12/7/1989. As per the school admission register, as per the evidence of PW3, the headmaster of Kodapkoda Primary School, on whose production the school administrator registered, as per the school record, the date of birth of the victim is 12/7/1989. As such, by the time of incident, the victim had already attained 18 years of age. As per the evidence of the prosecutrix, she and accused both were in love with each other, and the accused assured to marry her and then develop physical relationship with her. As such, she was a consenting party to the sexual act. From her evidence, it is not proved that because of the assurance of the accused to marry her, she was tempted to have sex with him.
Appearance preference. Yes. Yes.
22. 22.
Right.
Here 22.
22.
Item 22.
Appellants have been convicted for the offense under 304B of the Indian Penal Code and sentenced to undergo RI for 7 years. And with regards to 498A, for 2 years and to pay fine of rupees 2,000. No conviction with regards to 4 of TP Act. Here, whereas the entire case rests on evidence of 2 witnesses. So 3 witnesses, ballot PW 5, 7, and 8.
304B and 498A.
Madam.
2 years. 7 years.
7 years. Here, Madam, evidence of PW 5, 7, and 8. The last occasion I had drawn my lord's attention, the entire case rests on a letter purported to have been written by the deceased, Exhibit 5. My lord, PW 5, who is the informant and related to the deceased as father, he has not stated about this letter in the body of the first information report. My lord, first information report is at page 27.
Page?
Page 27, madam.
27. Yes.
He has not stated about the alleged letter which was written by the deceased before her death.
No reference to the letter.
No reference to the letter.
Exhibit
5. Let me see. The small letter written in Bengali. I was showing my lord the last occasion the English version of the same. The letter is a small letter without mentioning anything. And that question was put to my learned friend. And investigating officer has also stated that this letter was not produced during investigation.
Yes, sir.
PW 5, ballot by C, paragraph page 59. My daughter also gave me a letter containing the demand of dowry. I have filed the said original letter today, as I had given to police earlier Xerox copy.
Reading where?
Page 59, last 3 lines.
59. Okay. This is PW5.
Madam, my daughter gave me a letter containing the demand of dowry. I have given the said original letter today, as I had given police earlier Xerox copy. This is the said original letter written to me by my daughter, marked as Exhibit 5. 7 days thereafter, the brother-in-law of my daughter informed me that my daughter Lakshmipriya is admitted by medical hospital. Admitted medical hospital at
Baripada due to illness.
Brother of the, it has been also put to him, this witness, but in paragraph, page 61, paragraph 2, 6th line, it is not a fact that I have not mentioned in my affair regarding Exhibit 5, nor I have stated before the police regarding Exhibit 5. It is not a fact that the in-laws of my daughter did not demand Godrej Almira dressing table and 20,000, and I depose falsehood. It is not a fact that my daughter did not give me Exhibit 5, and that Exhibit 5 is not scribed by my daughter, which is a false document.
Yes.
Brother examined as a PW7, brother of the deceased. He says, I have not stated anything about Exhibit 5 to the police directly.
Who?
Brother of the deceased.
PW?
7.
Page
64. I was examined by the police after 1 month of the occurrence. It is a fact that I did not state before the police that my sister was entreated for 20,000 and that my sister sent Exhibit 5.
64.
64, paragraph 3.
I have not reported the matter before the police after receipt of the letter Exhibit 5. Did not send information to the officer.
But in chief, there is status. After the marriage, when my sister Lakshmi and her husband Antajan came to our house, we came know about their demand of 7 to 8 days prior to of my sister. Lakshmi Priya received a letter.
Okay, let us complete. Let him complete. Then actually, yes.
My learned friends draw ballots attention to the chief, where he has stated after marriage, when my sister Lakshmi Priya had and her husband Antarjami came to our house, we came to know about their demand. It was earlier no demand was there, but demand subsequently 7 to 8 days prior to the death of my sister Lakshmi Priya, we received a letter from her containing
demand of dowry
20,000. My sister Lakshmi Priya read up to class 7. Class examination. When I came to know about the demand from my sister during her visit to our house, I informed this to our mediator, Atul Patra. Neither Atul Patra and any of our family went to the house of in-laws of my sister to complain regarding the demand. We have also not reported the matter before the police after receipt of the Exhibit 5. We also did not send any information to the in-laws of my sister after receipt of Exhibit 5. I was examined by the police after 1 month of the occurrence. It is a fact that I did not state before the police that my sister was entreated for 20,000 and that my sister sent Exhibit 5. Another witness, PW8, with a maternal uncle.
Yes.
My house is at, he has stated about same 20,000.
Para 2
He has stated about 20,000 and with regards to Exhibit 5.
60.
This Exhibit 5 ballot, which prosecution is banking upon, If that will be taken into consideration, nowhere it is there about 20,000.
Yes, yes, yes.
My niece,
Because-
Lakshmipriya sent
See, Exhibit 5.
my niece, Lakshmipriya, she revealed her parents that her in-laws ill-treated her
Exhibit
and
5.
demand. Also, the informant
The English one?
not arrest
Yes,
his demand. Died.
May I read that Exhibit 5 letter?
We will come to that. These are the reference to the Exhibit 5.
Yes, Exhibit 5 earlier that was the seized by
Now the case goes like this. Through a letter, she demanded
Yes.
20 lakhs, 20,000 rupees. And these witnesses have said that after that they have not intimated the police. This is what is the evidence comes. Let us see exhibit. Where is the exhibit?
Exhibit 5. That is the letter written in the
Bengali.
Where is that?
Exhibit 5.
Exhibit 5. It is not there, no? Get the exhibit 5.
Pranam Pujanya Babu.
8 minute exhibit color. Let me get it. Exhibit 5. Yes.
Yes, ma'am. Pranam
You
Pujanya
have,
Babu.
you have translated.
Yes, in the some Bengal person there.
Uh-huh.
পত্রে প্রথমে আপনি আমার প্রণাম গ্রহণ করিবেন এবং গুরুজনদের আমার প্রণাম জানাবেন আপনাদের ওখান এক ফেরার পর বাড়িতে অশান্তি চলছে 20,000 টাকা ন দেওয়ার দিনে বাড়িতে সবাই আমার প্রতি অসন্তোষ
Displeased with me and
অসন্তোষ
treating me bad.
আমার সাথে খারাপ ব্যবহার করেছেন আপনি অবশ্য টাকার জোগাড় করার চেষ্টা করুন আপন কেমন আছেন জানাবেন This is the letter. And that letter was seized, Xerox letter was seized by the IO, that statement of the IO, my lord.
I'm coming to that.
Page 17.
But there was
Page
demand pertaining to 20,000. That it can be construed because 20,000 rupees was not given. Everyone in the house is displeased with me and treating me badly.
And
It cannot be termed to be by a torture. And the last occasion also, my lord was pleased to observe in considering in that spirit. Please do try to arrange the money. Let me know how all you are and yours so and so. My lord, this letter, my lord, about this letter, there was no mention in the body of the first information report because BW 5 says this was the letter received, written by my daughter, received by me, and he is the informant.
Yes, in the first information that are written. Yes.
First information report that is written.
Yes. ମୁଁ ଶୁଣିଛି ଏବଂ ଅଳ୍ପ କିଛି ଦିନ ପୂର୍ବରୁ ମୋର କନ୍ୟାକୁ ଅକଥନୀୟ ଅତ୍ୟାଚାର କରି 20,000 ଟଙ୍କା ମୋ ଠାରୁ ଆଣିବା ପାଇଁ ପଠାଇଛି। That's not the letter, but
that because only to bring about the presumption
20,000 thing is there, but letter reference is not.
Yes. Because law says 130 to attract 130B, there must be a immediate cause of action. To bring that immediate cause of action, they have introduced this letter, and that letter, the handwritings, whether they are written by deceased or not, that has not been sent to the SFL matter to ascertain whether this handwriting belongs to the deceased or not. Well, that has been, I'll go to the law on this subject later on. Well, here, IO says, if they have got the originals with...
Where is the IO?
IO matter?
17.
Page 17 matter.
17, huh? Yes, yes, page 79.
Page 79, page 80, that is written.
Schedule 70.
Page 80, 18th line.
1 minute. Page 80.
80,
Yes,
17, top 17
Yes.
line.
Where is that?
17 line. On 22/7/2001, the complainant Yudhishthira Giri produced one invitation card regarding the marriage of the deceased with Antarjam Giri and one inland letter, that is bracketed Xerox copy, to which I seized under seizure list as marked Exhibit 8/1, and this is my signature. There is marked by 8/2, and this is the shared invitation card relating to marriage of them. The Xerox copy of the letter issued the deceased to the complainant marked as Exhibit 16 with objection. On 22/7/2020, I
With
said already.
objection, but the Xerox
Yes.
copy is inadmissible as it is a secondary.
Yes.
Where is the original?
Yes, that
was
Exhibit 5 is
produced,
the original.
that was produced during trial.
Trial.
Exhibit 5.
That's the Exhibit 5.
And this letter, this Xerox copy of
No,
letter
it was produced through whom?
by PW5.
Let us see that part.
Madam, PW5. PW5, page 59, madam.
PW5, huh?
Madam.
It had introduced through PW5. Let us see PW5. PW5, page 59.
Madam.
Okay.
My daughter also gave me a letter containing the demand of dowry.
Hmm.
I have filed
59, last portion, na? Thereafter, my
Yes,
daughter
ma'am.
also gave me a letter.
I have filed the said original letter today, as I had given to police earlier Xerox copy. This is the said original letter written to me by my daughter, marked Exhibit 5. 7 days thereafter, the brother-in-law, viewer of my daughter, informed me about the death.
This my daughter, that is the Exhibit 5. Next page, that is the issue, that the postal stamp is indicated that 11/5/2001 that was issued.
ସେଇଟା ଆଗରୁ ହେଇଯାଉଥିଲା ତିଆରି।
You have not objected to it, huh?
Yes, opposed, but opposed ballot.
Where is that?
This when the IO has given that, we have opposed.
No, no, but when PW5 brought in that original,
Ballot that
you have not said anything.
this is the
You
Xerox
allowed this document to get in.
And
Well-
cross-examination has been made that this letter was not there with you, and you have not.
Where is the objection?
Objection? They have opposed with regards to Exhibit 16. This is the Xerox copy of the letter issued by the deceased to the complainant, marked Exhibit 16 with objection.
Where is that? Where?
Ballot, page 80, last but 8 line, ballot.
80.
This is the
80, yes.
This is the Xerox copy of the letter issued by the deceased to the complainant, marked Exhibit 16 with objection.
Oh, Xerox copy you have objected. But
And all.
and
IO
he
says
said
also the original of Exhibit 16 was not given to me by the complainant.
that the PW5 also says.
I have not given.
PW5 also says that.
Huh.
I gave
and this
Xerox copy I gave, original I gave. That's
Well,
what
the original which was produced during trial, or the Xerox copy which was with the investigating officer during investigation, that has not been sent. Minimum requirement is whether the letter, and it's a very important document, my lord, letter purported to have been written by the deceased before her death. And
no, the question is the original when brought in record
my lord,
through
no
PDF,
objection.
and you have no objected.
My lord,
And if you have objected, and thereafter this question arises whether you have to send to the handwriting expert.
original was produced during trial. It should have been done.
But
during
you have not objected to that.
No, my lord, PW5 produced Exhibit 5.
That time you have not objected.
But this letter should have been sent by the investigating officer during investigation, because the entire case rests on PW.
No, that should have been.
But that
The
has
original would
that
have
has
been given.
taken note of by this honorable court in the case.
But no, what will happen if the original is brought on record through PW5? There is no objection on your behalf.
That has been opposed in this fashion, my lord. The police did not.
If the original would have been given to IO, if he has not sent it to CFSL and all, one can understand.
It is not a fact that I have not mentioned in my affair regarding Exhibit 5. It was not there in a affair. Page 61, my lord, may see. Nor I have stated before the police regarding Exhibit 5.
It's not a fact that the in-laws of my daughter did not demand whether shown so and divorce was said. It is not a fact that my daughter did not give me Exhibit 5 and that Exhibit 5 is not scribed by my daughter, which is a false document.
This is
Jadi अन्य चिट्ठी थिला, that would have been given for comparison.
the suggestion.
Upon the
Yes.
It has been held by this Honorable Court in a similar situation in the case of 304B. Here, when the letter was Exhibit 10, which, I am reading the paragraph. So far as the cruelty aspect is concerned, the prosecution has relied upon a letter which is stated to have been written by the deceased to PW1. PW1 has stated that the deceased had written a letter, Exhibit 10, to him and sent it through PW2, who had visited Chandrapur, and that letter was seized by the police. He admitted that at the time of lodging the first information report, he had not produced the letter addressed to him, like the present case. He further stated that about a month after the discovery of the dead body, he had given the letter to police. Though PW2 has stated that while returning from the house of the appellants, the deceased gave her a letter to be given to PW1, and accordingly she gave the letter to PW1, but it has been confronted to her and proved through the investigating officer that she had not stated so in her previous statement. That is also PW8 say I have
regarding the letter, nothing was said. But here the photocopy was there.
I am coming to that. The investigating officer that she had not stated so in a previous statement about such aspect. Previous statement means 161 statement.
161, no reference to the letter at all.
PW2.
Yes.
Moreover, the letter was not shown to PW2 to during trial. PW3 has not seen, has not been shown the letter to identify the handwriting of the deceased.
Yes.
This is very important one. PW3 has not been shown the letter to identify the handwriting of the deceased. PW1 has stated that he had not read any in any school. The letter has not been sent to any handwriting expert for comparison with the admitted handwritings of the deceased and opinion.
But that fact scenario of that case is different in the sense in 161 statement in the FIR, nowhere that letter was referred to.
Yes.
But here
in the FIR it has not been referred to.
But 20,000 rupees is referred to.
20,000
not through the letter.
20,000 and letter is different.
Different, yes.
My lord. And the contents of the letter.
But photocopy was given to IU.
Photocopy
and original was brought in.
Photocopy is inadmissible in law is as a secondary matter. Because in the absence ballot like a post.
The primary evidence was brought in record without objection. That's the whole difficulty. मोटे क्वेश्चन पता देते हैं ऑब्जेक्ट ही है
but
cross you have asked many things.
But the fact that original was not given and no attempt has been made by the investigating officer to send it to the handwriting expert for comparison. In the absence of that, whether this letter will be accepted as it is. This is the question. And if my non-friend will say anything or any decision that yes, in the
minus this letter, what is the other evidence?
Nothing is there. Because to attract 304B, 130B is necessary.
How many years you have undergone? Come to the real substance.
My lord, that would be
because 7 years sentence.
My lord.
7 years.
Bail was granted in the month of December. During trial, declared. Husband was taken to custody. 20/5/1 and released on bail, I think. No, no. Bail ହେଲା 30/10/2003 ପ୍ରସନ୍ନଗିରି 80 years old. ତିରିଶ ଦଶ ପରେ ଦେଖ 30/10/2003 30/10 ପରେ 30/10/2003 ପରେ ପରେ 30/10/2003 ପରେ ଦେଖ ପ୍ରବଳ 30/10 इधर ये लगा कन्वर्ट के 이글이 अंचल नहीं एक कोट ने और देखो
Doctor, how she died?
When I committed suicide, the doctor said, doctor is PW3 madam.
PW3, huh?
57.
Just see period undergone with this. PW3.
And then doctor, sorry, doctor is.
No, PW3.
Doctor is PW2.
PW2 man.
PW2.
I found he says, at paragraph 2, on the query made by IO, I had opined against the query number 1 that the viscera was preserved, sent for chemical analysis, which no opinion could be given. Against query number 2, I had opined that pink color blood coming out during PM examination due to pulmonaris following argon phosphorus poison. The query is bad. Organophosphorus poisoning. Poisoning. Let it be. Just committed suicide. No external injury, nothing. Committed suicide.
PW5 is the informant. PW5 is there, founder and father.
Other opinions.
And he is informant and
PW17 is the IO. We have seized that phosphorus and that was sent to the chemical exemption report. That is the chemical exemption report is there also, exhibit 17. And in the evidence, I see the bog killer powder having the
phosphorus poisoning.
There is poison and one bedsheet is such and such, such and such.
Committed.
And a description of the exhibit A, one paper packet, marked the exhibit A, contain one paper packet with a JB powder containing 40 gram of glycine powder. Exhibit B is one paper packet, marked exhibit B, containing one white color regal cover with some stain stated as a vomiting substance.
Admittedly, she has
result is an organized phosphor. Incidental poison was dictated in the exhibit A and B. That is the chemical exemption for it.
Bog killer powder poison.
What happened to section 4? Section 4 acquitted.
Section 4, nothing is there.
Any finding in so far?
No, initially section 4 was there, but finding that minute.
Charge was framed.
Valid.
Section 4. There is no discussion of section.
No discussion about 4.
Section 4 also.
Only valid the accused persons, Prasanagiri, Chanchalagiri, Antarjamgiri, though found not guilty under section 4. Not discussion about 4. One plea was taken by the accused person. He was mentally disturbed. That has also been stated in 313 as well as it has been put to PW5 also. Discussion with regards to 4 is not there.
What will be the consequence if 4 is no discussion, nothing, 4 you are acquitted? Then 498, how will you
with regards to dowry demand, nothing is there.
That part goes.
And with regards to its rebate, the 498A and 304B. And my lord, he has accepted.
304B is because of for the presumption. Presumption. And in the absence of 4, how will you read 498A?
If there is no dowry, why touch it?
Just see the judgment, it doesn't deal with 4. Charge was framed under 4.
Yes, ma'am.
And simply last 2 sentences it writes not found guilty under 4. If the evidence is not sufficient, 4 goes, then exhibit 5 goes. Because exhibit 5 can be relatable to 4 only.
4
demand of dowry. Demand of dowry.
Demand of dowry.
5 is exhibit 5 is relied upon for the purpose of demand of dowry.
Yes.
And once you acute under section 4, then the relevancy of exhibit 5 goes.
And if the relevancy of exhibit 5 will go on,
what evidence is there thereafter? We have been examining about exhibit 5.
Yes.
Once he is acquitted under 4, then the relevance of exhibit 5 goes. Then barring Exhibit 5, what else you have?
490 case, demand of dowry is not a added.
Torture.
Any torture. That may be arising out of demand of dowry.
No, the expressions are there. See, it says come to 498A. Come to 490. See, the entire case revolves around one exhibit, that is Exhibit 5.
Yes.
We have been examining. Through Exhibit 5, it is said that he has demanded 20,000 rupees. Okay? And how it has come, first photocopy was given to IO, thereafter through PW5, the exhibit original was brought on record. He has not objected, or all these evidences are there. But Section 4, he has been acquitted. The demand of dowry goes.
Section.
Through that evidence only demand of dowry was there. That is goes.
Oral evidence is there.
Huh?
Oral evidence is also there.
That we have not examined. I'm only tasting Exhibit 5, relevancy of Exhibit 5. That goes. Then in the light of that, now come to 498A.
Yes, ma'am. However, being the husband or the relative of the husband of a woman, subject to such woman to cruelty shall be punished.
Any cruelty. Cruelty.
What kind of cruelty you have? Nothing, evidence re. ତାକୁ ଟର୍ଚର କରାହେଲା ସେମିତି କିଛି ନାହିଁ ଖାଲି ଡିମାଣ୍ଡ କରୁଥିଲା ଡିମାଣ୍ଡ ଦେଇ ପାରିଲାନି ସେ ଟର୍ଚରର କ'ଣ ଏଭିଡେନ୍ସ ଅଛି and see the explanation read the explanation we are testing it now don't worry we are testing it come to explanation 498 explanation read it.
For the purpose of this section, cruelty means any willful conduct which is of such a nature as like to be drive the woman to commit a suicide or to cause a grave injury or danger to life, limbs or health.
Okay, this portion you have to show me the evidence. This portion. Second portion come.
Harassment of the woman, where such harassment is with a view to a coercing her or any person related to her to meet any
unlawful demand. This is Exhibit 5.
Demand.
This is Exhibit 5. Exhibit 5, if the second part is there, then 4 has to be there. Section 4 has to be there. If Section 4 goes, the second explanation goes. And now you have to show me the evidence insofar as
first explanation.
Then you can survive 498A.
Here the cause of death is due to
Poisoning.
Those evidence has to be seen. We have not examined. Only Exhibit 5. See, the Exhibit 5 relevancy goes if the explanation B goes. Isn't it? After he being acquitted under Section 4, the second explanation to 498A goes. So only first explanation is there. To satisfy first explanation, you have to show me the evidence. Read it and tell me which are relevant. We have been struggling for understanding the Exhibit 5. The trial court only records on the basis of Exhibit 5, Section 4 acquitted, 498 and 304 convicted. But besides that, there are other evidences also. You show me those evidences. Okay. I'll pass it over. You read it. You have a difficult task now. Read it. Yes, I know that. You just read it. In that light, you read it. And only to satisfy explanation 1. Because 2, you can't perhaps rely because he has been acquitted under 4. You have not appealed against that. And undergone period also, you just tell me so that if the conviction is maintained, we will modify the sentence. Okay. Partner. Next Tuesday. I'll dispose it up.
Yes, sir. Only if date mentioned in case of failure of any of the installment. That will be there.
It will be revived.
Yes.
Liberty is granted to revive. And whatever he has paid, that will go. That's their loss. ଦୁଇ ଲକ୍ଷ ଟଙ୍କା ଦେଇଛନ୍ତି ଆପଣଙ୍କୁ whatever 2 ଲକ୍ଷ ଦେଇଛନ୍ତି ବର୍ତ୍ତମାନ ଯଦି we will not able to pay the remaining amount that 2 lakhs will go and you will revive. I'll record that. At least you got 2 lakhs.
On the installment, you pay to demand draft.
Yes,
yes.
15 na? I'll just 1 minute. Over here. Just wait, I'm giving dictation so that there won't be any confusion. 15. ଗୋଟେ କରିଦବା ତିନିଟା ଯାକ ତିନିଟା revision ଗୋଟେ କରିଦବ but the convictions are different na
amount is different
conviction orders are different na
yes madam
in all the three
yes madam
huh?
yes
First to go to revision into the petition is arising out of so second so since the aforementioned three revision petitions are arising of dispute regarding the one-off check issued by the petitioner,
yes,
which is petitioner, and to petitioner have been convicted by the court below, which has been confirmed by the first appellate court. The petitioner, by way of the aforementioned three revision petitions, have assailed the judgment of conviction and order of sentence. When the revision was, all the three revisions were taken together, since the dispute is dispute is between the common dispute between the petitioner and respondent. During the pendency of the revision petition, the parties have entered into a out-of-court settlement and out-of-court settlement. The affidavit, the petitioner has filed an affidavit dated 13/7/2026, pointing out the terms of in para 2 to equal record of the terms of also. The respondent, the counsel for the respondent on instructions submits that his clients are agreeable to such terms of settlement. To demonstrate bona fide, the petitioner, by way of demand draft, following demand draft, 2 lakh rupees, he has paid 2 lakh rupees in the court today. The counsel for the respondent had accepted the demand draft by placing an acknowledgement on record. Both the counsels appearing for the parties conjointly submits that all the three revision petitions can be disposed of in terms of the affidavit dated 13/7/2026 by the petitioner, only convict, petitioner or convict. It is also agreed between the parties that the installment to be the date of installment, the installment to be paid towards the settlement amount is to be abided by the petitioner as per the terms of the settlement. In the event of failure on the part of the petitioner to comply the timeline of the payment of the installment, the respondent would reserve his right to revive the revision petition by moving appropriate application before this court. The petitioner, besides the affidavit dated 13/7/2026, also undertakes, he was present in the other, also undertakes to comply the terms of the settlement scrupulously. It is relevant to mention that on the last date of hearing, that is on when was that? That is on 9/7/2026. The petitioner who be convicted was present in the court, and he has made a categorical statement that whatever the settlement terms is worked out, he will be complying the same. In the event of his failure to comply the terms of settlement, the petitioner would have the right to revive the
opposite party.
revision petitions. Revive the petitions. In the event the petitioner fails to comply the terms of the settlement, the advance amount, the amount paid by way of first installment, that is rupees 2 lakh, shall stands forfeited, and the liberty would be stands forfeited, and the revision petitions would be revived application for this. This term.
Conviction and sentence.
And लिखी दूँ in the event the entire payment as per the schedule is paid by the petitioner, the judgment of conviction and the order of sentence passed in all the revision person stands set aside, and the petitioner will be issued. Yes.
This case can
In the event he is paid.
Yes.
Otherwise, yes.
This case can be 21st minute.
Which one?
Because
Yes, another matter.
Item 9.
9, yes.
May I
9.
please, Your Lordship? Item number 9, Your Lordship.
This should be allowed. This
Yes.
should be allowed. Because in your absence, I could not have done it. He has gone to America, it seems, by paying this amount.
Production of his returns, document in the proof of return
Oh,
of his,
Right,
He has already produced, Your Lordship.
I think you produced further. What is the
Yes,
problem?
yes, Your Lordship.
What is that? 12, na? Para 12, tha, na?
Yes, Your Lordship. Para 12.
Right. Petitioner by the order dated 8/10/2024, the petitioner was allowed to travel USA since the council, Mr. Maharana, council appearing for the Vigilance Department, raised the objection regarding the flight risk, possible flight risk. A condition was imposed by this court to for the purpose of traveling.
deposit of banker income from him.
The para 12 by way of para 12, the condition was imposed. The petitioner was directed to furnish a bank guarantee of rupees 25 lakhs as a security in lieu of his travel to USA for 3 months. 3 months. Para 12 of the order dates also reads agenda. And consequently, the petitioner submits that after the petitioner had traveled to USA for 3 months, and after returning back from USA, moved an application for discharge of the bank guarantee, which has been turned down by which order?
Lordship, order dated 6/11/2025, Your Lordship.
Where is that order?
Lordship, Annexure 1, Your Lordship.
By the order dated turned down by the learned Special Judge Vigilance Bhubaneswar, by the order dated 6/11/2025. Just see last paragraph, para 13. The petitioner worth consideration in light of the aforementioned, it is allowed that the petitioner directed to permit so and so. Our original document has been given.
Submitted his original passport as per the
Furnished
order.
undertaking that he would return to India and so on so. That the accused had visited USA, and after return from the USA, he has submitted his original passport as per the order of the Honorable Court. Keeping in view, he has submitted.
Yes, Your Lordship.
Submitted the original passport before the court below and prayer for release of the bank guarantee. However, the same has been rejected by the trial court by the impugned order dated 6/11/2025. Hence, agreed by the same, he has moved this application. It appears from the para 30 for the impugned order, which reads as under that the petitioner, the contention raised by the counsel for the petitioner is correct, and after release of correct. Correct. In view of the specific order of this court dated 8/10/2025, the petitioner is entitled the order of trial court appears to be not correct, and the same stands modified. The petitioner shall move a fresh application before the trial court by furnishing the necessary document. ओरिजिनल तो दे दिला कौन पाई आगे दरकार नहीं
ओरिजिनल दबा एंड कोऑपरेट करियो ट्रायल तले
the trial court shall on the fresh application for the trial court for the release of position with an undertaking before the court that he shall cooperate with the trial without fail, and on such undertaking the bank guarantee furnished by the petitioner shall be released in his favor. Yes.
My lord, item number 29, when it was called, I couldn't show, my lord. 29.
Yes.
It may come in any other day, my lord.
326 months, 10 days.
6 months?
323, 6 months.
What do you want?
10 days undergone.
10 days undergone.
Sentence, yes, my lord. There is a matter also, my lord. I will argue the matter in next day, my lord.
What? Small matter, argue today only. After lunch you argue. Read it.
Okay.
After lunch you argue. 10 days undergone.
I don't have power, my lord. Yes,
I am appointing you as an amicus.
Yes, ma'am.
What power? 323.
323.
Conviction 6 months sentence.
Yes,
10
ma'am.
days already undergone.
Yes, ma'am.
Either I'll allow you already undergone, or you want PO, I'll give PO. Read if there is a case of acquittal. I will
Yes,
read. Read it. Take the evidence from
Yes,
here. Read it.
After lunch, my lord.
After lunch.
Yes,
Okay.
Mm.
29. Yes.
The appellant has been convicted under section 323 and 6 months imprisonment. The appellant, along with 2 others, they were facing trial, and 2 other co-accused persons, they have already been acquitted,
Mm.
who were with the same footing with the appellant. And in the case, there are prosecution stories that while the informant, who is PW2, she was with her in her house. Her husband, PW7, went to the nearby well to fetch water, and after a while, the informant.
Use mic, huh? Yes.
The prosecution story is that while the informant PW2 was in her house, her husband PW7 went to nearby well to fetch water. After a little while, the informant heard a sound of assault, and hearing such sound, she came out from her house and saw that near the village well, her husband is laying on the ground, and the appellant, along with other 2 accused persons, jointly assaulting the husband. And she couldn't rescue her husband, so she went to inform the Sarpanch, and who is PW6. And there are total witnesses are 11 witnesses.
Who is injured?
PW7.
Come to 7.
This happened as well. Other two were acting.
I couldn't.
PW7
But the other witnesses have said that they have seen all the accused assaulting.
But
This is on record shows that only this happened as well. For that reason only two others were acquitted by the trial court.
But just come to PW2.
Seven.
PW2.
PW7
PW2, come to PW2. First paragraph. I found the accused Kirtan assaulting my husband with a bamboo lathi and also with a knife. My husband became unconscious and fell down. He had also sustained injury on the leg and hand. I called PW1 and shouted that the accused persons had assaulted. That means he has also not seen.
Yes, my lord. Manoj, she claimed to be an eyewitness, but PW7 has stated in his chip that only Madhav was there at the spot.
The
Except
PW2
Madhav.
also has said that
Yes, madam. She
only
stated-
Kirtan has assaulted.
I have, she's the eyewitness. She claimed to have been the eyewitnesses, but in her chip, even regarding the weapon of offenses, she has stated that the accused person, all the accused persons, they have assaulted knife and lathi. But in her deposition, she has stated that weapon of offenses are lathi and bhujali. So there is a huge discrepancy in the weapon of offenses, my lord. And
Doctor?
with regard to
PW8.
PW8,
Since the X-ray plate was not produced.
there are 5 injuries, my lord. There are 5 injuries. Out of them, 3 injuries are simple in nature and 2 are grievous in nature, which is stated by the PW8. But the grievous injury, which is about uprooting tooth, that has not been deposed by anybody. No witnesses have deposed regarding that. And also the fracture one. My lord, kindly have a glance in page 7 of the judgment.
Yes.
There are 5 injuries and 2, 3, 4. There are
Para 12.
Yes, my lord, para 12.
Yes. Yes.
PW8 is a doctor who was working as MO and he has examined the injured. The following injuries are one, which is a fracture, depressed fracture, and 2, 3, 4 is simple in nature, and 5 is the tooth has been uprooted, which is the grievous in nature.
Yes.
But my lord, that with regard to fracture, kindly have a glance in page 18.
Yes. Page 8.
Page 18.
1-8.
In middle para. It has been stated that in view of the above decision and the evidence of prosecution witnesses, it is concluded that the prosecution failed to establish the essence of the offense under 307 and 34 of IPC, but as the assault by means of lathi causing injury on the head of PW7 has been established, it makes out a case 323 of IPC. Though the doctor PW8 deposed that the injury number 1 is grievous injury, but neither X-ray plate or the CT scan report has been proved properly. So the doctor does not say only the injury number 1 is dangerous to human life in ordinary course of nature. With regard to injury number 1, which is the fracture, that has not been corroborated in any documents, medical report. And with regard to uprooting tooth, my lord, no eyewitnesses, including the informant.
So that is not believed. That is the reason it is 323. Otherwise,
yes, my lord. Even the not even injured. Not
either it would have been
stated that
it would have been 325, 26 or something.
Yes, my lord. And regarding with regard to weapon of offense, my lord, there are discrepancies in it, which is in FIR the informant has stated that injured has been assaulted by Pujali and Lati.
That is why 324 is not there.
Yes, my lord.
Weapon is not there. 324 is not there.
And
Grievous hurt is not believed, so 325 is ruled out. The weapon of offense is not proved, so therefore 324 goes. And 323, because the injured is saying, the witnesses are saying, the doctor also finds.
witnesses are saying that all the accused persons have assaulted, but when the two other
Who has said all the accused persons?
the PW2, my lord. She has
PW2 has not said that. Just see. PW2. He saw Kirtan was assaulting, but he told PW1 that all are, just see, read it. I found accused Kirtan assaulting in between. Para 1, para 2, in between. I found accused Kirtan assaulting my husband with a bamboo lathi and also with a knife.
Yes,
my husband became unconscious and fell down. He had sustained injuries and so on so like. I called PW1 and shouted that the accused persons had assaulted my husband. He has not seen, only Kirtan has, but he told the PW1 that everybody is assaulting. That's the reason.
Typographical error.
Huh?
Typographical error is the accused person, person से.
Whatever. Even if persons नेले भी, से देखी नहीं, थी मारी वाला देखी नहीं. And what about the
after
Biragi Bishwalo?
They have been turned hostile, my lord.
Biragi Bishwalo, Sohita Malik.
Madhava, they have been turned hostile.
Them. These are the three witnesses. They have witnessed the. Okay.
Except Saita Naik.
Let us see Sarita Naik. Who is Sarita Naik?
PW3.
3. Let us see.
Other 2 have been turned hostile.
Let us see 3.
She stated that Kirtan Vishwal assaulting.
Where is that? Coming to the blog and found that Kirtan Vishwal assaulting so and Lathi so and so. And such injury so and so. I asked Kirtan Vishwal not assaulting. Sorry. My lord,
the whole story it was came out of the previous enmity, which has already been reflected in the judgment. That
previous enmity is a double-edged weapon, you know. You have assaulted because there was a previous enemy.
That page 5.
Motive is there then.
Page 5, my lord, of the judgment.
5 of the judgment.
The son of the informant had taken away the daughter of Anadi Bishwal, which is one of the co-accused.
Yes.
In the course of cross-examination of PW1, Lord, page 5, in 7th line. In the course of cross-examination of PW1, she has stated prior to the incident, the son of the informant had taken away the daughter of Anadi Bishwal, who was one of the co-accused, my lord, who was facing trial, for which the meeting was convened in the village. From the mouth of PW2, the defense brought out the meeting had held in the village to solve a dispute of taking away the daughter of Anadi, namely Usha, by Balabhadra, and the said meeting was held prior to the incident. This incident happened before the alleged incident. So there was a previous animosity, my lord. PW3 is the only independent witness. All interested witness.
PW3.
PW3 is
says only Kirtan assaulted Lakshmindra.
All are tempted, so that is the reason other two are.
and two haven't turned hostile, who were the eyewitnesses.
So that's the reason the other people were refuted. 10 days undergone.
9 days.
9 days.
11, 2003.
27,
11.
20?
7, 11, 2003.
7, 11, 2003 to?
No, 18, 11, 2003 to 27, 11.
18,
11, 2003.
3 to?
27, 11, 2000.
Okay.
He was on bail during trial.
First offender.
First one, he was on bail.
Okay. I grant view.
Number 26.
Willard, I don't have a power in this case.
Give your name. What is your name?
Baishaki Mahanti.
Give me your name. MAKIS report. MAKIS appointed MAKIS. Is yeah? Okay. I appointed MAKIS.
Yes, my lord. Oh,
Thank
please.
you. Thank you
Oh,
for
please.
asking. Yes.
Item 26.
Give your name so that in the other matters also. Natalie, click with you. How could you make this?
6.
Yes.
May I give the last one? My lord, in item 28, I want to take the TCR.
Take?
In item 28, I want to take the TCR.
Oh, you can take. Get your pen drive and take it. Yes. Yes, sir.
Well, here's the present appellant, my lord. Charge for offense under section 376, read with the section 3(2)(b) of SC Act and section 511 of IPC, my lord. In alternative, it was charged for 354 and section 3 of SC Act, my lord. So for 3 of SC Act is concerned, he has been acquitted on that act on the ground that the investigation was done by SI of policeman. The accused faced trial for offense under section 354, convicted under section 354 and sentenced is 1 year, my lord. You know, kindly have a glance at the FIR, my lord. That the allegation, the informant is the
This is 20, this is 26. 26.
Mother of the victim, my lord. He lost this FIR.
Yes.
And the offense here is 376, 511, my lord. Along with 3 SC Act.
Let us see the prosecutories.
My lord, for the movement, my lord, FIR. Why I am certain, my lord, they have totally done the FIR and their story in other part is totally different story. For that reason, also kindly have a glance at the FIR, my lord.
Yes.
Both mother, daughter, and other witnesses.
Who is the author of the FIR?
Mother of the victim, my lord. Ashanti Hemra, PW1. ରହୁଥିବା ସମୟରେ ଆକ୍ୟୁଜ ଆସିକି PW1 ନେଲେ।
Yes.
The allegation clearly reveals that he attempted to commit the rape, my lord. Forcefully attempted to commit the rape. That is there in the FIR. So far subsequent part is concerned, the victim was never examined by the lady doctor, that is Page 73 of.
Let us read the FIR. Somewhere more Geo Kumar is from so Ammo. What?
ପାଠ ପଢିବାକୁ ଯାଉଥିବା ବେଳେ କ୍ୱାର୍ଟର ନମ୍ବର ଏତିକିରେ ରହୁଥିବା ସମୟରେ ଆକ୍ୟୁଜ ଝିଅକୁ ହଠାତ୍ ଆସି ଉଦ୍ଦେଶ୍ୟମୂଳକ ଭାବେ ପାଶବିକ ଅତ୍ୟାଚାର କରିବା ନିମନ୍ତେ ଆତର୍କିତ ଭାବେ ଜବରଦସ୍ତି ମାଡ଼ି ବସିଲେ। ତାଙ୍କର ଏହି ସବୁ ଘଟଣାରେ ଝିଅ ଭୟଭୀତ ହୋଇ ଚିତ୍କାର କରିବାରୁ ଝିଅ ମୁହଁକୁ ହାତରେ ବନ୍ଦ କରି ନାନାଦି ପ୍ରକାର ଗାଳି କରି କହିଲେ, ତୁ ପାଟି କଲେ କିମ୍ବା କାହାକୁ କହିବୁ ତେବେ ତୋତେ
Evidence. Yes. Please go to